Yes, good evening to the advanced private international students. Now I put it something on the screen. Please unmute and read what I put on the screen. Oh, it is again disappeared, but doesn't matter. Yes, now you can read what I kept on the screen. Read.
As human being evolve, the law also has to evolve.
Yes, as a human beings evolve means they take a different status and progress. The law also has to evolve in the to keep the pace with them. So that is the reason the law will change when the society will be changed, and the law should be in pace with the society change. That would be the actual thing. So why? Because all the theories are one way in another way. It will be a supplement only, and there is no firm. A particular theory is very much perfect, and there is no such a thing would be there. That is the reason we will make it out. A different theories would be adapted when we solve the problem of the conflicts. So in my last class, I was dealing about, means yesterday class, criticism of the local law theory. What are the criticisms they said is, while precedents can be a good basis for deciding on conflict, yes, the local laws precedents, which is already decided and which will save the time also. So that will be a quite good law. They shall not be the only basis on which any future decision shall be made. Suppose the president of the 5 years back or 10 years back, at the time, the system is different, the social conditions are different, but now the conditions are changed over there. If you apply the same precedents, the decided law, at the time it will be the injustice to the parties. Because I told you, human being evolve, the law should be evolved. That law should be changed. Sometimes it is not good, but now it is good. And today only I saw a WhatsApp group. It is sent by to me by the Indian friends. Even a sex business is a profession. That is the Supreme Court of India has given the decision. I repeat, even a sex business is a profession. The Supreme Court of India have given the judgment. But at the time, sex is a taboo earlier. Am I right? Am I right?
Yes, sir.
Because having a sex before the marriage or at the schooling is a taboo. So now they say it is a business, it's a profession without qualification. Don't you think that law will be evolved because of this society? Society make a sex as a business. So that's why I told you human being evolves over there. The law should be evolved over there. Though no precedents will not work over there at the time. In case a president is obstructing justice and failing to achieve the full potentials, then such a president shall not be followed any longer. Suppose the president would be there in the olden times, not olden times. For instance, you take in East Africa or African continent, FGM, mutilation of the genital organ. It was there, but the human rights, they said, they banned it, and even all the countries domesticated it. Do you think that still the FGM is there in Tanzania? Yes? Answer.
I don't know, sir.
No. Female genital mutilation, that is no more practiced now in. But in certain Korea, is it Korea? Korea tribe, they only follow, they said. But even they also got the awakening, and such a practice is no more now. So that is my study or my opinion. So in other countries, for instance, you take in India, there is no such a FGM. So evolving that slow by slow, so it will be banned, and there would be a law would be there. If any person forces for the FGM, then he will be punished. So now the court should also be ready to set aside the precedents if it discovers in future that the president has led to miscarriage of justice. Suppose if the same precedent would be used over there, and that is a miscarriage of justice would be, and hence it will be changed. And the question comes over there: can the High Court overrule its own decision, or can the Court of Appeal could overrule its own decision? Answer. Answer. If you know it, you tell me. If you don't know it, you say pass on. Yes. Raymond,
Yes, it can.
it can, even High Court as well as the Supreme Court, Court of Appeal. So here, that's why I said, I quoted here this statement: as human beings evolve, the law also has to evolve. Therefore, basing any law solely on precedents cannot be correct every time, because at that time that is good, but now this is good. A great example of such is the power of the high courts to overrule the earlier judgments of lower courts, or even their own judgment also. In many instances, we have seen the courts overruling their previous judgments in the light of a new facts and a logical questions that arise will time on the previous judgments. See, I told you, no. The judgment which is given earlier, at that time it will be a suitable one. Because of the evolving of the human beings, a different culture and different system, now the law should be changed over there. So that is the conditions will prevail. Hence, local law theory will not be a quite good theory to make the private international law. But in one way, in another way, in conclusion, it will be said now. Now let us see the theory of justice. Then this theory of justice was developed by the Dr. Graveson, and with the only basis of delivering true justice. The sole idea of this is true justice will be delivered over there. I don't think whether it is possible or not. True justice, because when you want to make a true justice, actually the counseling also be like that from the standing council of the different parties. If the standing council is not that much perfect, naturally we cannot give the justice. Of course, sometimes even a judge may self question it, and they will see, try to get the information from the council and to produce such information, because he doesn't want to say that there should be a miscarriage of justice. So ideally, Dr. Graveson also believes that his theory is not straight jacket. See, he himself is accepted. It is not a straight jacket rule for every case possible, but his main aim is to deliver pure justice, keeping in mind precedents and having good conscience and equity. Of course, precedents should be followed over there, but in the simultaneously, if the society will change over there, then the law should also be changed. So there would be a good conscience, and there should be equity principles also evolved over there. So in the words of the Graveson, I quote, one of the English, I repeat, one of the English legislative and judicial justice based on what English statutes say and what English judges do in case of to which conflict of laws applies. It is thus both pragmatic and ethical. So pragmatic means practical, and ethical. A judgment which is there delivered the president in the last 10 years back, and that will not be a good justice at now because of the prevailing situations, and hence the presidents cannot be made it over there. A true justice can be followed. So they say the theory of justice. Sir, how could a judge will decide it? The judge will decide it by logical reasoning, number one. The way that you present the case to the judge, and he will take which theory would be the good enough to give justice to the parties, then he can adapt out of 5 theories any one of the theory if it is applicable. If not, he will follow the connecting factors. If not, they will follow the treaties or the charters and the bilateral or unilateral, bilateral or multilateral treaties should be there and agreements are there, then they will follow it based on that one. So according to him, to whom him means Graveson, Dr. Graveson, private international law has a threefold premise. The premise is threefold, namely sociological, ethical, and legal. The social aspects also will be taken into consideration when they are disposing the justice. And ethical aspects, whether it is ethical, now the question comes over there, sex profession is ethical? Tell me. Tell me.
No, sir.
It is not ethical.
No.
It is not the good way to make it out. The reason is it will lead to the hukumvi. There are many other factors are there. And everybody will buy a ticket and goes to the like a cinema hall. So it is not ethically good. And the legal aspect, they say every woman is having every right to sell her body, but it is not the ethically good in such a way. So sociologically they made it so because they need the money, but it's not the way to get the money by selling the body. You work and get in a good way that you lead your life. Otherwise, if your children are born at the time, who is the father, even herself doesn't know. Am I right? Am I right?
Yes, sir.
That is true.
Yes, sir.
Sociologically, it calls for a need for the fair treatment of private transaction of individual internationally. So social aspects, ethical aspects, legal aspects, the Graveson emphasizes. Ethically, it speaks about the desire of the English courts to do justice by looking at the training and tradition of the jurors, judges, and lawyers and their day-to-day delivery of justice. Lastly, legally, it rests on the terms of the oath and judges. So now the question comes over there. The judgment which is given over there based upon the standing council which is convinced the judge, number one, and sociological aspect also it will play and how it can be done. And the judge may use their discretion, not discretion, a logical reasoning based on the proofs or the documents produced over there, and he will give the judgment. As stated earlier, Gibson himself talked about his theory not being a perfect one. He said it's not a straight jacket. This is so because in many instances one cannot explain in terms of the absolute and empirically developed principle in this, as in the other branches of law, and may lead at time to hard individual cases. So now question comes over there. If you see a justice, sometimes the justice seems to be done, and accordingly, sometimes it will be miscarriage of justice also. So it depends upon the judge to decide to which theory could be applied over there to see that the parties, those who comes to the court, they should not be disappointed. So that is the point they will make it out. So it brings one to an important conclusion as to no particular theory can properly answer the question. Any theory, you take statute theory, local law theory, territorial theory, any theory, including this ethical theory, that is justice theory, they cannot be perfect in all means. So time being, it will be used depending upon the case law and the nature of the cases are concerned. And that is the clearly mentioned. Theory cannot be properly answer the question, what are the theoretical basis of the private international law? While some scholars base it on territory, some scholars based on local theory, and some scholars extended the version of the same principles. The major issue here is that cases of the private international law, one is to bound to apply some or the other foreign land, but no one is willing to concede such a laws. So, conceding to the foreign laws and applying them while determining the conflicts only means one sovereign is giving up its sovereignty in front of another sovereign. Suppose every country is a sovereign country. At that instance, when they want to conceding the other laws of the other country, that gives the sense that they are losing their sovereignty. No, it is not the question of the losing the sovereignty. Harmonizing the issue there, that is a very important factor. Harmonizing the issue. See, the conflict should not be lengthened. Harmonize the issue, because without the cooperation of the other countries, no country will develop. I repeat, without the understanding and the cooperation of the other countries, no country will develop. Am I right? Am I right?
Yes, sir.
It is true fact, because every country having a good relation with the other country in the export and import and manpower exchange and many other factors. Don't think that only one thing, everything will be available in only in Tanzania or only one country. No. Other countries are rich in other minerals, natural resources, and including the agriculture, including the skill and education, medical, medicine, IT technology, and many other factors are concerned. And if you happen to see in the world, mostly from the IT technology and medical from the India. Have you observed? Yes? Have you observed?
No, sir.
Yeah, you check it, statistic you see, and most of the people are there in the IT technology and medical from the India. Because of there will not be a good opportunity there, brain drain is there, and they don't want to use their skill because of the various other factors. That's why they will migrate to the other country and they will live over there. That is a different issue is there. Okay, let us come to the, while Shesher and other points out that such a subordinate one's sovereignty does not occur by force, such a sovereignty gives up its sovereignty by free will. See, it is not that if you give the reverence to the other country law, it doesn't mean that you are losing the sovereignty. Because if you give the reverence to the other country law, that country law also give the reverence to this country law. It is called, what is the doctrine is called? What is the doctrine is called? What is the doctrine is called? Comity. COMITY. I will give the respect to your decision of your country, and simultaneously you also give the reverence and respect to our decision of our country. So that is the comity theory. However, in cases of the private international law, one does not really have a choice. But here the question comes, choice depends upon what are the connecting factors are there, number one. Number two, whether the justice would be given to the party, disposed to the party, educated to the party, and that also we consider. Then different theories and different connecting factors could be used, then they will decide the case. It is called as a private international law because it involves the interest of the more than one party which is in conflict. Here, there should be a other country subject should be there, a foreign body should be there, then only you can say it is a conflict of laws. And thus, it is inevitable that some of the other foreign law is applied to resolve the cases of such conflict of interest. Yes, in certain cases, definitely the other country law should be followed over there. Then only it is a justice should be given to the party. Otherwise, it is a miscarriage of justice if you are firm about the law of the forum. If you firm about the law of the forum, it is an injustice to the party. Hence, the other country law would be, decision will be taken as it is to implement here, and that is a good justice to be given. So all theories are, no one is perfect. Like a human being, can a human being is a perfect man? Yes? Give me the answer. Whether the human being is a perfect in all means, answer no. Answer no.
No.
Everybody is having their own deficiency. So now in the conclusion, let us say, see, when you are writing the conclusion, especially dissertation, you are not supposed to write it in this way. I told you when you are teaching the dissertation, side heading always small letters, but the first letter should be bold in every word, and except the conjunctions, prepositions, and articles. That is the rule I have given. So conclusion should be, C should be capital letter, the rest of the other letter should be small letter, and any subject, any heading, any subheading, any side heading. This is a side heading. This is a side heading. Never goes in a plural form. Try to be a singular form as much as you can. Am I right? It is a principle.
Yeah.
It is a principle. I know there are issues, but don't write ISSUES. Right? Issue. ISSUE. Dosha. So now, private international law or a conflict of laws is a vast and ambiguous field of law. It is an obvious factor because in one case we apply one rule or one theory. In another case of the same fact, we will apply the different theory. At that time, that's why we can say, depending upon the situation, we have to change the theory and factors, connecting factors. Hence, we can say the ambiguous field of law, and essentially, there is no single theory, I told you, that completely and effectively underpins the application of the law when there is a conflict with the foreign laws, because every country is having its own law. Like I told you just now, the Supreme Court has given the judgment that even a sex business is a profession. So conflict of laws become a variable playpen with the judicial policymakers. It depends upon the policymakers how they could want to make it out. The courts are saddled with the cumbersome and unwieldy body of the conflict law. Saddle here means sit over there. Actually, saddle, you know what is saddle? Do you know what is saddle? Yes? If you know it, you tell me. If you don't know it, you say pass on. Raymond,
Pass on, sir.
Pass.
see, horse, you know horse? When you ride on the horse, you cannot sit on the back of it. There is a seat is there. They tie the seat, and that seat is called saddle. Here, a saddle in the sense, in one way, a seat to arrange it. I will show you what is a saddle. Actually, that is the meaning of saddle. Saddle images. I think I am right. Did you see it? Did you see it?
Yes, Prof.
Yes.
On the horse, the seat is there, no, that is called saddle. Means decide or set. That is the meaning you have to take it. Not this meaning. The seat of on the back of the horse is called saddle. So now we'll go back again. Where is this? Yes. So now they say they cannot saddle on that with the cumbersome and unwieldy body of the conflict of laws that creates a confusion and uncertainty and inconsistency as well as the complication of the judicial task. So nations in our contemporary world are so much interdependent. See, I use the word interdependent, means dependent on each other. Interdependent, that they have got to cooperate mutually. We should not say that we don't respect your judgment. No. Because other countries have a good law where the judgment is very much perfect. At that instance, very perfect judgment should be taken into consideration and apply. in our country, even though there is no such a decision would be there. So that is again, having got to cooperate mutually, all the nations, all the countries, then it need not be said that the contact of the people of the world with each other at the international level has grown so much that the wheel of the clock cannot be put back now. So I told you in the beginning when I was teaching you, when I was joining the University of Dar es Salaam, the private international law is restricted to the prospectus only. There was nobody to teaching. But after coming myself, Professor Ibrahim Hamisi Juma, now the Chief Justice of Tanzania, he told me, Hussein, you introduced such a course here so that people will remember you. So I took it the private international law because I taught this course 3 years in the University of Asmara, Eritrea. That's why I picked the course. Then only the course is optional course at the time. Only optional course at the time. 3 years I taught as an optional course. But the TCU felt, no. This course should not be an optional course. They say it is a core course. Because now world is a hamlet because of the globalization and liberalization. And the people migrate from one country to another country and marry in one country and die in another country and have the education in another country and youth in other country, marry the other country girl. So that would be the nature. So the private international law became a core course now, and it should be put only in the final year only. And that to be final year first semester, that is very good because the second semester you have the dissertation and other things are there. So in short, it is the international social need that has given birth to a private international law. It is a social need because each country will be dependent on other country, interdependent, have the cooperation, mutual understanding, and they do agree to a particular norms, and hence the private international law has emerged out, took birth because of this interdependent and people migration, people moving from one country to another country where the dispute arises over there, and the private international law plays an important role, and it is taken birth by that one. So, and so long as this need exists in the private international law, will stay, whatever the exercise may be made to find out its theoretical basis. So, private international law will not be removed from the syllabus now. It will be a compulsory course to study like the Tanzania Penal Code and a law of evidence, law of contract. So, in that way, it should be become a compulsory course. And one more connecting factor is there that is called depicage. I don't know whether you heard it or not. Have you heard this word? Depicage. Depecage in private international law. Have you heard this word? No, it's a simple word. Okay. If there are two alternatives are there in the system, choose the one which is very much useful. Choose and select. That is actually the depicage meaning. The concept is the theory of the depicage is a concept in a private international law that refers to the process of cutting a case into individual issues. If a case is there, you make it into two pieces and choose, pick and choose, or choose and pick. Which one is the correct way? Yes? Which one is the correct way? Choose and pick or pick and choose? Please. Tell me.
Pick and choose.
Pardon?
Choose and
Pick is the right word. It is choose and pick is the right word. That is a depicage also choose and pick. A issue will be cut into the two pieces, two systems, two modes, and choose which is the best one among them, not among them because only two are there. Choose between the two and pick it. That is called depicage. So depicage also plays an important role as a connecting factor in some places, and it will, you have to impress to the judge and judge also will be impressed and accept it. Pick and choose method. So that is a depicage, we will say. I have taken the photocopy of that thing, but it come blurred. So I will say that because in all books we could not get it, we get only some books only this is depicage. Of course, Cheshire and Foot is there. Cheshire book is there, and there we will get it definitely. North and Cheshire, something. So what I want to say is these are the things would be there and how it can be made. Even depicage also one of the method. But I already told you that I posted you the 15 questions. I don't know whether you saw it or not. Did you see it? Sir, we never see the email.
Yes, Yes. I did.
Yes. So here one.
Yes,
Here.
yes.
I put it over there. There is one question is there, and which deals about the connecting factor. Did you see it? And I have a small video clip of the connecting factor. At least you can enjoy it. It will be a repetition to you. It will be a repetition to you. And if you see it, now let me say where I put it. That Google Chrome share. Let me open. Check it, then I will show you. Yes, I found it here. Rules. Yes, this is the thing which I want to make it out. Okay, just a minute. It is gone. Okay, let me share it because we have to. Yes, I shared it. Then I could not see where it is disappeared. Okay, so much are there. Yeah, I found it. Just a minute. I'm sharing. Yes. Now you could hear it. Are you hearing? Raymond, are you hearing?
In this lesson, we will begin our discussion on connecting factors.
Very good. Please.
Now, by and large,
Yes, Prof.
this lesson will connect
Listen.
up, so to speak, with pretty much every other topic in this particular course. Because fundamentally, connecting factors are concerned with actually connecting or subjugating a person with some form of legal system for any certain legal purposes. The reason for this is you might have heard of the generalized terms that everyone is under the law or everyone is affected by the law. And therefore, in order to be affected by such laws, one must be connected with some form of law. Now, globally, this is either by means of your nationality or domicile. Nationality is by and large Lexpert 3 based on where you are stationed or where you are currently residing. It'll differ. For example, in terms of a European jurisdiction, nationality plays much more heavier of a role than that of common law countries such as the UK. Because of this, our fundamental or our essential focus will be on that of domicile. First and foremost, what amounts to a domicile and why do we consider this as such? Basically, on the one hand, a domicile is one of the primary aspects, just like we considered a bit earlier, which connects a person with the law of a country, specifically that of UK or a common law country. Domicile is paramount in establishing the connection of an individual with the country. The principles then of domicile is that things which you need to remember as such would be firstly the fact that there is no possibility of a person without a domicile. No person can be without a domicile. No person can have more than one domicile at a certain time either. You can only have one specific domicile at any given point, and an existing domicile is presumed to continue until there is a usurpation by a new domicile. And this new domicile must be one which is proved. These three principles, or rather these three main structures or pillars of identifying domicile, has been outlined in the seminal case of FNF. Now, considering the fact that on the one hand, you can't not have a domicile, on the other hand, you can't have more than one, and that you are the one who must prove a new domicile, and that an existing domicile doesn't simply vanish, there are a number of types of domiciles that we must consider throughout this particular lesson. One of the precedent types of domicile, one which all of us are entitled to, is what is known as a domicile of origin. Everyone acquires a domicile of origin at birth. It's basically where you're born is where you're domiciled. If you are a legitimate child, though, on the one hand, the domicile of your father is usually the domicile that you have. If not, it's the domicile of your mother. This can be changed only in relation to an adoption. If you are a person known as a foundling, someone who has been found by another individual, it is where you were found. Now, what must be noted in this context is that you will by default have a domicile of origin. This goes to fulfill or substantiate that first requirement or the first principle that we just looked at, which is the fact that no person can be without a domicile. So originally, by default, you will always have a domicile of origin. Now, besides this, you might also have what is known as a domicile of choice later on. This is where an independent person can acquire a domicile of choice by a combination of either your residence where you are and your intention to reside as such. And we'll go into this a bit more later on in this particular lesson. But basically, a domicile of choice, as the name itself suggests, is when you yourself have voluntarily taken up a particular domicile by virtue of your actions or your conduct. A lesser presumed or a lesser discussed type of domicile is that of a domicile of dependency. This amounts to, in terms of married women at one point of time, now of course this is quite defunct, in relation to children, like we considered a legitimate child acquires the domicile of a father, for instance, and on the other hand, that of a mentally disordered person. Now, in relation to number 2 and 3 that we just looked at now, you'd note that where capacity of the individual is insufficient to have a domicile of choice, there is a domicile of dependency that is appended to that particular individual. Now, one of the fundamental aspects that I noted earlier that we need to talk about is that of domicile of choice. There are two primary prerequisites in order for an individual to establish that he has chosen a domicile and that is his particular domicile. On the one hand, it is that of residence. So in terms of residence, what we are looking at is the fact that there is some sort of physical presence and inhabitation. There is some form of physical presence or habitation of a particular locale or location. But this need not, as per White and Tennant, be for long durations. What's most prevalent and important is that you can identify, prove, and establish that this is your habitual place of residence. Now, an immigrant, for example, is capable of acquiring a particular residence if, in fact, he or she intends to settle in that place. And this component of intention is quite important and something that we will have to look at throughout the course of our study in conflict of laws. Conversely, you have to not only substantiate and define your residence, but also the fact that you intend to reside for an elongated period of time or a period of time which is not substantially limited by any means. So this intention must be permanent or indefinite, but if a person intends to leave on the fulfillment of some contingency, let's say the fulfillment of an employment contract, it might negate the intention of that indefinite or permanent residence in that particular domicile or location. So what must be understood then is that this fulfillment or contingency can not be vague or indefinite either. So if it's something, for example, if you say, I'm going to live in this place until I win the lottery, for instance, it's an indefinite contingency. It's not the same as suggesting that I have an employment contract for 1 year, so you know that there's a finite period of time that you can actually stay there. If it's only something which is foreseen or reasonably anticipated, that domicile of choice may be negated due to a lack of the necessary intention of the person. A few case law is actually quite prevalent, and you might have noticed in terms of private international law or conflict of laws, wherever we use case law, it's by and large connected heavily to the principle itself. So you don't necessarily have an abundance of case law as such, but whatever case law that we do have, no matter how limited it is quite directly connected to the principles. So on the one hand, you have Ross and Ross, which outlines in terms of intention that a person's claim must be fortified and carried into effect by the conduct and action consistent with expressions made. So in essence, what the law looks at is not what a person says, but what a person does and what the conduct infers. On the other hand, Udni and Udni specifies that the residence freely taken without an external necessity, such as duties of office and demands, or illness, is that to showcase intention. In essence, what Udni is actually outlining is the fact that if something is foreseen, if you are known to be completing a particular contingency within a period of time, you cannot show that you have taken up residence freely by any measure. No information is too trivial in determining this intention, as outlined in Drevon. That's why every single context, every single aspect of the conduct of the person matters in determining whether intention is prevalent. Now that we've outlined the domicile of choice, the next aspect that we need to look at is that of dependency. By and large, where the domicile of the dependent is and changes with the domicile of the person to whom they are dependent, this is when the crux of our conversation begins. The first type of a domicile of dependency is now quite defunct, and that is of married women. By and large, at one point in time, it was in fact the use of the domicile of the husband. So when marriage occurs, it is in fact the domicile of the husband. But you might recall from a previous lesson in this course that there are perplexing decisions which take place, such as Ogden and Ogden. Conversely, you have two scenarios in which you would note that due to the lack of the necessary capacity of the individual, we would have to append, or we would have to add some sort of domicile of dependency. On the one hand, you have children or any individual which is under 16 years of age. In such a situation, in case of a legitimate child, the domicile of the father will be that of the child, and in case of illegitimate children, it will be that of the mother. Whoever the adopted parents are in relation to an adoption, wherever their domicile is, that would be the child's domicile as well. Conversely, when it comes to a person who has some form of mental disorder, in essence incapable of discerning certain aspects, then the domicile is original, the domicile of that person before he or she became mentally disordered. If, however, that individual is mentally disordered from birth, then he or she is considered as a dependent, and therefore it is the domicile of the person that he or she is dependent upon that will be the domicile of that individual. Now, apart from this, there are several other aspects that we might need to consider based on a problem scenario or a question that is presented to you during an examination. Domicile does not necessarily limit itself to these three situations or these three aspects. There are, by and large, many other scenarios in which we may have to encounter during an examination situation. So on the one hand, for example, prisoners will retain their original domicile irrespective of where they are housed or where they are kept after their incarceration or throughout their incarceration. Persons who are liable for deportation, in such a situation, the deportation order alone is insufficient to negate any domicile that they had acquired at that concurrent moment. If a person goes to a country merely for work purposes alone, that individual will not get domicile of choice. There's an interesting case of the Chief Justice at one point appointed or assigned to Sri Lanka, then Ceylon, which is in this case of AG or the Attorney General and Roe, which I urge you to have a look at. So this was a situation in which employees or an employee's domicile of dependency was in question, and what the court held was that a mere work-related relocation doesn't amount to a new domicile of choice. That was a succinct overview of connecting factors, a fundamental or an essential topic in relation to conflict of laws. Without connecting factors, we are unable to really progress and understand what types of laws and jurisdictions are applicable in relation to an individual. From the next lesson onwards, we will go in depth into understanding the concepts behind jurisdiction and how exactly recognition takes place, as well as enforcement from there on. Thanks a lot for watching this video. Click on a subject of interest to learn more.
So you have seen it too. How is the connecting factor plays an important role? Participants, are you there? Participants. Dorcas. Dorcas. Are you there? Nobody would be giving the answer to my question. So you heard my video. Connecting factors, without it, there will not be possibility of the resolving the disputes. Dorcas, tell me.
I did. I had the video.
You watched the video. What they said, without connecting factors, there will not be any conflicts. The resolution would be there. So connecting factors plays an important role. Is it or not? Say yes.
It is.
Yeah. So there is a question given. That's why I thought that let me share, because my teaching, addition to that one, if you could hear like that, you could follow it. At least repeatedly you can watch my this YouTube so that you could understand what is there. Suppose if it is a physical class, one time teaching over, because today I did not have the internet facility. That's why there when that today I could not record it, the LLB law of tort where I taught the defamation, because of there is no connection would be there, and hence I have to give the physical lecture only. Out of the 400 students, 290 students are present today class, and tomorrow we will see that how many would be present over there. And tomorrow, if God wills, and if there is internet is available at the place, then I can record it so that the other people, those who misses my class, they can